So JD has dropped another courtroom bombshell, this time calling out that nameless person's evidence, saying that it is fake. See, JD accuses her of stonewalling and stalling, saying that she will not turn over the evidence for examination. And if she truly is confident in the legitimacy of her evidence, then what exactly is she trying to hide? Now, the judge has already said that she needs to turn over we're going to review this 7th request for production. That's right, 7 requests and counting. Buckle up, because it is an insane and kind of hilarious ride. Oh man, so hey there to all you fine folks on this fine day, by the way. I hope you are doing excellently. And you want to know the funniest thing about all of this? If you look at that timeline right there, the trial 4/11/2022, and you think about all of these bombshells by JD, you know whose fault that is? It's not JD's fault. He didn't give you more time. No, it's that nameless person's fault. They keep delaying. They keep trying to make this stuff not happen. And JD, he keeps coming up with more and more evidence, and this stuff, it makes that nameless person look bad. Oh, and speaking of looking bad, you have this monster of a filing. When I say monster, by the way, I'm talking about 337 pages all told, asking for the production of original devices, of operating system drives, of cloud backups of the original devices as requested by JD in the 7th set of production requests. That's right, 7 sets and counting. Make no mistake, this is a call out too, in which JD, he pretty much says the evidence that nameless person has provided or is going to provide has been staged, modified, or otherwise falsified. In fact, JD's experts have already determined that at least some of that nameless person's photographs have appeared to run through photo editing programs. But as they note very clearly here, they do not know the full extent of this manipulation without a forensic examination, and that's exactly what they're asking the court to provide. Now, they continue with this, and I love the way that this is laid out, because it's not an if that nameless person did it, it's when that nameless person did it. When did they manipulate this data? That nameless person relies heavily on electronic data from her personal devices to support her claims, and will doubtlessly seek to introduce such evidence at trial. Of course she will, by the way. Of course she will. It's imperative that JD be afforded the opportunity to examine this evidence to analyze when, whether, and by what means that nameless person has manipulated it. You notice that wording there, has manipulated. So that isn't a did they do it again, that's a when did they do it. Then they bring up something very interesting. They bring up the idea that nameless person has asked for this type of information for JD, wanting to go through his devices, but they won't produce the same type of stuff from theirs. Why exactly is that? Quote, despite propounding similar requests for forensic analysis of JD's devices, that nameless person has stalled and stonewalled JD's efforts to obtain access to devices on which her evidence is maintained, even with the common sense protections for privileged information JD has proposed. That nameless person's reticence begs the question, if she has not falsified her evidence, then what is she hiding? Now that, in my opinion, is a very, very solid question, especially when you consider the next portion in the background, that being that JD has already hired an expert, and guess what? They've already found manipulation. That's right. JD seeks to test whether this evidence has been manipulated or manufactured. Now, to that end, JD picks up his own person to go over this. I'm going to call that person Brian N., by the way, who is a court-certified video, audio, and digital photographic forensic and technical expert with over 20 years of experience analyzing data evidence and data in law enforcement and legal proceedings. Now, right here is where things get really, really spicy. And it's interesting, the type of bombshells that you find really innocuously planted in documents like this. Listen to this, drink it in. So Brian N. has already analyzed photographs that nameless person produced in this action that purport to show injuries she suffered from JD, and he determined that these photographs have gone through a photo editing application. Read that again. He has determined that these photographs have gone through a photo editing application. That's right. She swore in the UK that none of that happened. Basically, you were looking at raw data. They couldn't have gone in. They couldn't have manipulated this at all. And yet here it is right here. You have a court-certified expert saying, oh yeah, it went through that. And you can tell, by the way, just by looking. Now, the expert goes on to say that they don't know how bad this manipulation is. That's why they need the originals here. They need the raw data, and they ask for that, and they give instances of what could possibly have taken place. So Brian advises, however, that he cannot assess whether the metadata associated with these photos or any other electronic data that nameless person has produced has been modified in any way. Now, here's your examples, and really drink these in, too. For instance, changing the date or time a photo or video was taken. That's a big accusation, by the way. That was alleged in the UK. The judge would not let that be followed up on. And that, yeah, you definitely want that checked out. Or whether any relevant data has been deleted from that nameless person's device and thus not produced. That would be big too. And they did find data associated with that nameless person's sister that they didn't turn over within the UK. So just remember, that has happened. Without obtaining a forensic image, specifically a physical or byte-to-byte image, and then they go on what they need with this. Now, as far as their argument is concerned, it's a pretty simple one. They're saying allegations like this, along with photographic evidence and the like, needs to be examined by everyone, including JD. I mean, that makes sense, right? Quote, under Virginia law, the scope of discovery extends to, quote, any matter not privileged which is relevant to the subject matter of the action, including discovery related to the party's claims or defenses. Here, JD alleges that nameless person defamed him when she publicly accused him of, you know exactly what she said in the op-ed, and that her allegations are outright lies. Testing the authenticity and the veracity of these photos and other documents that nameless person is cited as evidence could not be more relevant or critical to the central issue, whether she made everything up. Whether this purported evidence is authentic, accurate, and complete can only be determined by forensic imaging and analysis. Virginia law does not prevent that nameless person to offer these kinds of allegations while depriving JD of the ability to determine whether her evidence has been modified or manufactured. Like I said, that right there, it's a very simple argument. It's an argument very much grounded in law. And that nameless person, they can try to delay this. They can try to delay the inevitable, but sometime it's going to roll around. And yeah, people are going to get to look at that. They're going to get to look at the dates. They're going to look at that raw data. And yeah, it's going to bite them. It's going to bite them big. But anyway, let me know what you think about this stuff. And as always, I appreciate the heck out of you. You make this stuff work, so thank you. Want to help out the channel? Well, there are links in the description. Plenty of them at that. They help us out immensely, so check them out. But you being here, that matters too. So thank you. I appreciate you. Going to end here with a thank you again and a see you soon.